Joining us today. My name is Kayla Hooven, and I'm pleased to welcome you to Foley's Employee Benefits broadcast. Today we will be hearing from Marian Dodson, Isaac Morris, and Chris Ward. Marian is an associate in Foley's San Diego office. She works with ERISA, church, and government retirement plans, and self-funded health plans, including self-administered health plans. In this presentation, Marian is going to cover IRS enforcement of Affordable Care Act employer mandate penalties and the status of the EEOC wellness regulations. Isaac is special counsel in our Milwaukee office, where he focuses his practice on employee benefits, executive compensation, and ERISA issues. He also advises clients on federal tax issues arising in M&A transactions. Isaac is going to discuss updates regarding summary plan descriptions and disability claims. Last but not least, Chris is a partner in our Chicago and Los Angeles offices, representing and counseling employers throughout the country, with particular emphases on class action litigation, wage and hour issues, and labor relations matters. Chris is going to take a look at joint employment issues. Before I begin and turn the presentation over to our speakers, I'd like to go over a few housekeeping items. For those of you that have questions today, please feel free to submit them via the Q&A widget. We will do our best to answer them if time permits, but will otherwise follow up via email after today's webinar. If you are seeking CLE credit today, please enter the code, which will be announced later on in the presentation. If you would like to download a copy of the presentation, please see the PDF on the resource list widget. And lastly, we would appreciate it if you would take a few minutes to fill out the short survey on your screen and provide any feedback on today's webinar. And with that, I would like to turn the presentation over to Marian.
Thank you, Kayla. So I'm going to jump right in and get the worst of it over with and talk about ACA employer shared responsibility payment notices. As you know, the employer mandate kicked in 2015, and it generally requires large employers to offer affordable health coverage to their employees. And if they don't, those employers may be subject to the employer shared responsibility payment if one or more of their employees went out and purchased insurance through the marketplace and got a premium tax credit for that coverage. So now the IRS has started mailing out letters to employers who might owe the payment. The letter is template letter 226J, and should you receive one of these letters, it will contain the IRS's preliminary calculation of the payment you owe, and you will only have 30 days to respond. So if you have the misfortune of getting this letter, you might ask yourself, how did this happen? Well, you might get it if any of your people got a premium tax credit for their purchase of marketplace coverage and you did not offer coverage to enough of your employees, or you did, but the coverage was unaffordable or did not provide minimum value. You could get the letter at any of your entities, so each of them should be on the lookout. And even if you cover all of your full-time employees, you might still get the letter because one of your employees or independent contractors incorrectly filled out his marketplace application, or you may have errors in your own reporting. In any event, no employer is immune, and so all should be on the lookout for this letter. So you'll recognize it. I'm putting up a PDF of the first page of the letter. The letter will have a spreadsheet showing a monthly breakdown of your employer shared responsibility payment amounts, which will add up to the total that the IRS thinks you owe for the year. Here's what that spreadsheet looks like. So now what? Well, you only have 30 days from the date of the letter to respond. You have two choices. You can pay the amount the IRS calculated, or you can object to the IRS's determination. If you object, you will need to explain the basis for your objection and provide supporting documentation. Either way, you can use the enclosed Form 14764, and regardless, it's really important that you do respond in some way, shape, or form by the 30-day deadline, either by paying or objecting. If you object and the IRS does not agree with your supporting documentation, you will have an opportunity to request a pre-assessment conference. But the important thing is to respond to the letter 226J and start the process. If you don't, you will receive a notice in demand from the IRS demanding full payment subject to interest and lien enforcement. And needless to say, nobody wants that. So now what I'm going to do is move into avoiding getting these letters in the first place by engaging in accurate and timely Affordable Care Act reporting. First, here's the good news. There's still a tiny bit of time because the IRS extended the deadline for furnishing Forms 1095-C or 1095-B to employees to March 2nd, which is the day after tomorrow. And anyone who e-files has until April 2nd to file the forms and the transmittal form with the IRS. Or an e-filer can get an automatic 30-day extension by filing a Form 8809 by the April 2nd deadline. But if you don't e-file, then your deadline is today. And so you should put that Form 8809 extension request in the mail right now if you have not already filed with the IRS. So you've hopefully already completed these forms for 2017, but I still want to alert you to a couple of tricks you might be able to use to expedite the filing of these. First of all, if in the previous year you were a small employer, which means you had an average of fewer than 50 ACA full-time or full-time equivalent employees, remembering that ACA full-time is an average of 30 hours per week, and you're not part of a larger employer group that had 50 or more, and you purchase insurance to cover your people instead of self-insuring, then you do not have to fill out these forms. And if you're a small employer that self-insures, then you can use the simpler forms 1094B and 1095B. But for the purposes of today's lesson, we're only going to talk about Forms 1094C and 1095C. So I'm going to put up a PDF of Form 1095C. And you can take a look at that form and see the three major sections, but I'm going to skip to Part 2, which is where you describe what you offered your employee. Part 2, line 14, asks you to enter a code for the offer of coverage. In this line, the IRS just wants to know what you offered the particular employee named on the form, not what they did or didn't take. So even if the employee refused your offer of coverage, you should still enter what you offered to them. And there's a list of codes the IRS requires you to use to describe the coverage you offered, and you should read over those codes, keeping in mind that this is the information that the IRS is mainly trying to get at. Did the health plan provide minimum essential coverage? This just means that the policy or plan meets the ACA individual mandate requirements, which your employer group health plan does. Did the health plan provide minimum value? This means that the percentage amount the plan pays of the total cost of coverage, which includes employee premiums, co-payments, and coinsurance percentages, is at least 60% of the total cost of coverage. So if you offer a plan with great benefits, but your employees pay too much of the cost, then that plan does not provide minimum value. The IRS also wants to know what you charge as premiums or employee share contributions for employee-only coverage. That is the cost of employee-only coverage under the health plan affordable? But what you charge for the coverage of spouses and dependents is not relevant here. But it is relevant that they were offered coverage, and if there were any conditions on coverage of the spouse, the IRS wants to know about that too. So the first trick I'm going to talk about is using Code 1A in line 14 to cut down on the information you have to report on this form. Here are the requirements for using that code. You can use that code if you offered a full-time employee minimum essential coverage, providing a minimum value, which was per se affordable using an index percentage of federal poverty level, which was a maximum of $95.93 per month for self-only coverage for a 2017 calendar year plan. And also, in order to qualify for using Code 1A, you have to have offered that employee's spouse and dependents at least minimum essential coverage. The upside to using this code is that for any month that you made a qualifying offer to an employee, you don't have to fill out lines 15 and 16 on the form. And only if your plan is insured, you can use alternative method statement reporting instead of Form 1095-C for any full-time employee who received a qualifying offer for all 12 months of the year. But again, that only applies if your plan was insured. If you're not making a 1A qualifying offer, then you will have to read over the codes and the instructions to figure out where your specific offer of coverage fits. Once you figure out the line 14 code, you can put it in the all 12 months box if the person had the same offer of coverage for every day of the month of the year. But you have to be careful here, because what if someone was in a waiting period? Well, then you didn't offer them coverage for those months, and the answer is 1H for those months. And what if someone was not working for you for part of the year? Again, the answer is 1H because you did not offer them coverage during that time period. And for a new employee who has coverage that starts on the date of hire, but that date is mid-month, you still have to use code 1H because they did not have an offer of coverage that covered the whole month. Remember that in line 14, the service is just looking for the offer of coverage, and they don't want to hear your excuses at this point. That comes later in line 16. Okay, so moving on to line 15, the point of this line is to make a claim that the health plan you offered was affordable. But now remember, if you used code 1A in line 14, then you've already said that the coverage was affordable, so you should not fill out line 14. Excuse me, you should not fill out line 15. You also don't have to fill in line 15 if you've already said in line 14 that the employee was part-time all year, or if you said you did not offer minimum essential coverage, or that the coverage did not provide minimum value. If you do have to fill in line 15, then the dollar amount to put in this box is the employee share contribution for employee coverage only. The extra money that people pay to cover their spouses and dependents should not be put in this box. And if you offered different plan levels, you can use the cost of the lowest plan that is still minimum essential coverage, providing minimum value that you offered to that specific employee, even if they chose more expensive coverage. Okay, the last line in part 2 is line 16, which is, pardon me, I skipped ahead, which is really important because this is where, for an employee who was not enrolled in coverage for the whole month, you have an opportunity to declare any safe harbors or explain why you didn't make an offer of coverage. For example, if your employee was in the health plan waiting period, you should put code D in each of those months, which will explain to the IRS why you did not offer coverage to that employee for those months. And remember the time-saving tip here. If you made a qualifying offer and put code 1A in line 14, then you don't have to fill in line 16 at all for any month in which code 1A is used. So that's all the time I have to discuss this form today. But just a final note, when you fill out part 3, remember to also list the employee and not just the spouse and dependents, and that if a person had coverage for even one day of the month, you should report that they had coverage for that month in part 3. And another fun tip, if you have an insured plan, then you don't have to fill out part 3 at all. So when you're done with all of that, you still have to fill out the transmittal form, which is Form 1094C, to transmit all of your Forms 1095C to the IRS. Here's a PDF of the first page of that form, and I'm just very briefly going to tell you that the key takeaway for this form is that if you offered affordable coverage, providing minimum value to at least 98% of the employees you're giving a 1095C to, and minimum essential coverage to their dependents, then you can check the box in line 22, and then you will not have to provide a full-time employee count when you fill out the transmittal. And if you're going to use the code 1A code reporting on Form 1095C, then you should check the qualifying offer method box on line 22 of this form also. Okay, so that's it for the forms for today. Just remember that you do want to nail the content of these forms so that you don't end up getting that dreaded employer shared responsibility payment letter down the road. Now I'm going to entirely switch gears and talk a bit about the EEOC Wellness Program regulations. The reason we're bringing this up today is because there are likely going to be coming changes due to an AARP lawsuit against the EEOC. As background, wellness programs offer incentives to health plan participants for a variety of actions. Depending on the program, the required actions could be something like walk once a week, or could involve filling out a health risk assessment, having a biometric screening such as a glucose test or blood pressure test, counseling about risk factors, or even something outcome-based like quitting smoking. And the incentives might be a monetary incentive like a premium reduction. And the background on these wellness regs is that HIPAA prohibits discriminating in plan eligibility or premiums based on health-related factors, but has exceptions for certain wellness programs. And the ACA expanded those exceptions to allow incentives of up to 30% for most wellness activities and up to 50% for quitting smoking. Now, two other statutes, and this is where the EEOC comes in, the Americans with Disabilities Act, the ADA, and the Genetic Information Non-Discrimination Act, known as GINA, also have prohibitions impacting wellness programs. At their most rudimentary, the ADA does not allow discrimination based on a disability, and GINA does not allow a plan to use genetic information to discriminate. So wellness programs that ask participants to answer health-related questions or to undergo medical testing are inherently problematic under these laws. But the EEOC has issued regulations under the ADA and GINA to allow wellness programs under certain circumstances. Under those regs, you can have a wellness program as long as it's reasonably designed to promote health or prevent disease. It's not overly burdensome. It's not subterfuge for some other discriminatory agenda. And for people who need it, you need to offer a reasonable accommodation or an alternative standard and notice of that. Also, you need to provide a notice describing the wellness program and incentives, how health information will be obtained and used, and who's going to receive that information. And any medical information acquired through the program must be kept confidential and can only be provided to the employer in aggregate form, except as necessary for plan administration. And finally, and here's the point of contention right now, the EEOC's regulations say that incentives may be up to 30% of the cost of employee coverage and still be voluntary. The EEOC picked this number in order to be consistent with the 30% rule under HIPAA and the ACA. That seems kind of logical, right? Well, the AARP disagrees and sued on the issue of whether a 30% incentive is truly voluntary. The D.C. District Court granted summary judgment in favor of the AARP because the EEOC could not provide an explanation for why a 30% incentive is voluntary. The EEOC said it was trying to harmonize ADA and GINA with HIPAA and the ACA, but the EEOC did not provide any economic analysis or explanation for why a 30% incentive is truly voluntary. So ultimately, the court said it would vacate the EEOC's rules as of January 1st, 2019, and it told the EEOC to submit a notice of proposed rules by August 31st of this year and to file a status report by March 30th of this year. The EEOC then filed a subsequent motion asking the court not to set a rulemaking deadline, and the court said, okay, fine, but the existing rules must still be vacated on January 1st, 2019, and the EEOC still has to file a status report no later than March 30th. So the punchline here is that we don't know what is going to happen. So what can you do? Well, I wish we could give you more robust guidance here, but really all we can say is to be prepared for the fact that the current EEOC rules may be vacated for the 2019 plan year because we don't think the EEOC will be able to issue regs in time. And in the meantime, you are probably designing your 2019 plan in the coming months, and we think you should still follow the EEOC regs. But if you don't have a wellness program now, but you were considering adopting one, you might want to postpone that until the 2020 plan year when we will hopefully know more. Anyway, that's it for me today, and here is Isaac Morris.
Thanks, Marian. So I'm going to jump right in as well and start talking about summary plan descriptions, or SPDs. Excuse me. So as you may know, an SPD is just a document written in non-legalese language that describes the plan's terms, its benefits, and any participant responsibilities. And it needs to be written in a manner that your average participant can understand. So that means that you want to do things like use simple declarative sentences. You want to be liberal with your use of cross-references and use them. meaning if you're talking about eligibility in one section and you think it might be helpful to talk about the matching contribution, but you don't talk about that in depth until later on, make a mention of that to your reader and refer back to things as well. And what I'm trying to get at with that is you want to make it difficult for your reader to get confused. Also, if you have rules in the SPD, and that's very common, you want to not only explain the rule, but the consequence of what happens if that rule isn't followed. So don't forget the other side of the coin there. Material changes to the SPD require a formal amendment that's commonly known as an SMM, or Summary of Material Modifications. And I bring this up here just because you'll see in a later slide there are some pretty liberal time requirements on when that has to be provided to participants. Don't wait for the Christmas rush. Consider informing them as soon as possible, possibly through an informal communication beforehand. As you can see, this slide provides a list, non-exhaustive, of both things that have to be included in the SPD and things that we think should be included. And just focusing on the should column for a moment, for discretionary authority, you want to make sure you have a sentence or two in your SPD about this, saying that, hey, the plan administrator and any delegate has the ability to interpret plan provisions to make factual determinations. As far as the statute of limitations, that's basically just a shorthand way of saying, hey, if you have time requirements, again, common, such as there's a certain amount of time to file an appeal or to file a claim in general, then you want to make sure those time limits are described in the SPD. A non-waiver clause is basically just saying, hey, you as plan administrator, if you decide not to enforce a particular provision, you want to make it clear that that doesn't mean you can't enforce that provision later on and that you're not waiving anything else. Make it clear to participants that they need to cooperate as well. And for instance, maybe by accepting a benefit, that the participant knows that they're also agreeing to perform any act that's required or needed by the plan, such as signing a document. And then finally, no one knows your employee population better than you do. So if you're aware of a unique situation that you think would be helpful for everyone to know about, go ahead and describe that in the SPD. You'll see at the bottom, I made a note about the new disability rules, and I am going to talk about those later on. That is something to also keep in mind when you are looking at and reviewing your SPD. So who's responsible to provide the SPD and who's getting it? The general rule on the former question is that it's you. The plan administrator, usually the plan sponsor, is responsible for providing it. Sometimes we'll see that contracted out to an insurance company or maybe the third-party administrator. Just remember that even when you do that, that ultimately the buck stops with you. So if there are any problems getting that thing distributed, ultimately it comes back to you. As far as who gets it, covered participants should always be receiving the SPD. And if we're talking about a retirement plan, then it's not only just the covered participant, but any beneficiaries who are receiving payments. Just a reminder here not to forget about some special situations, maybe less common situations. For instance, if you have any folks who are on COBRA or you have retirees who are receiving or are entitled to benefits, make sure they're getting a copy of the SPD as well. This is a favorite slide of mine. When do you provide it and how do you have to do that? So the general rule on when is that you should be providing that SPD anytime someone becomes eligible to participate in the plan, and then periodically thereafter as the law requires. And I'll just draw your attention to the third bullet point down there, that the SPD should be provided every 5 years. Technically, you can go out to 10 if there are no material changes. That's more rare than it is common. So it's a good idea to have that 5-year reminder, that tickler on your calendar to distribute it then. You'll also see that in some of these parentheticals, there's some pretty liberal time requirements for when the SPD or an SMM has to be provided. Again, as I referred to earlier, there's usually no reason to wait. Get them out as soon as you can. And in the case of an SMM, again, consider notifying people informally ahead of time. As far as how it gets provided, the general rule to start with is that it needs to be provided through a method that's reasonably calculated, to ensure actual receipts. So acceptable safe harbor methods, meaning you're deemed to satisfy that first requirement, they include first-class mail, distributing it hand delivery in person. Electronic delivery can also be a safe harbor method as long as the people that your employees have computer access, and that access is integral to their duties. Now, it's not an automatic disqualification if you stray outside of these safe harbors. You just need to make sure that you're meeting that first requirement, that it's reasonably calculated to ensure actual receipt, and then you need to be comfortable with additional scrutiny that you might get as a result of going outside the safe harbors. So, possible additional scrutiny by the DOL. Let's move on now to the new disability claims procedures. And you'll see at the top of this slide the words compliance and readiness should be serving as hyperlinks to a couple of great newsletters some of my colleagues have written here. So they serve as a great resource as well and get into a little bit more of the detail than we have time to do through these slides, but we will certainly cover what we can. The new rules are effective for claims filed on or after April 1st of this year, and they apply to disability plans and retirement plans, both qualified and non-qualified, where disability in the plan is creating some sort of payment or benefit event. So that could be things like there's a payment event upon disability, or there's accelerated vesting, items of that nature. A gating question for these new disability rules is who's making that determination? Who's deciding when disability occurs? Is it you as the plan administrator, or is it a third party? And I'll discuss a little bit here and in a future slide as well. I say this question because do you need to comply with the rules, the nitty-gritty, as it were, or do you need to kind of monitor someone else, and maybe that's an easier role for you to do? The rules effectively don't apply to plans where the disability determination is being made by a third party. So if you have your LTD carrier making that determination, and in absence of that, it's the Social Security Administration, it might be an easier situation for you. You may still have a role to play, but again, administratively, it might be a better situation. Getting into the substance of the rules a little bit, there's a host of requirements, and I'll cover a few here on this slide. They're designed to make sure that people making these determinations are doing so on an independent and impartial basis. And so that means things like the adjudicator, the person deciding the claim, can't have some financial tie to the number of denials that they make. There are some pretty hefty improved disclosure requirements. There has to be a full explanation of any disagreements. So, for instance, if you consult 3 doctors, you can't cherry pick and just say, we're going to rely on the opinion of the doctor that we agree with, that we like. If 2 other doctors have a contrary opinion, you need to explain the disagreements. There's also a description, there needs to be a description of the contractual limitations period. And this is a big one because it's very common for plans to have an internal deadline by which to file suit in court after exhausting all the plan's internal claims procedures. So nothing wrong with that, but in a denial notice, not only do you have to state that rule, but you have to include the actual deadline, the specific date by which someone can file suit. So you can't just say, hey, you have a year from from the date of this letter to now file suit, now that you've been through the procedures, you have to specify the exact date. Failure to comply with these rules will not put you in a good situation. In general, unless we're talking about a very minor error, such a failure is going to allow the person to immediately file suit in court and bypass all of those great claims procedures that you have put together. So what do you need to do now? What should you be thinking about? Again, I want to go back to a few slides ago and that gating question that I posed, and that is, look at who's making the disability determination and maybe give some thought to, hey, do we want to make any changes to who's making that determination? For instance, in a retirement plan, let's say a 401k plan, is the plan administrator making the disability determination, or maybe do you want someone else to be doing that? Again, having your long-term disability carrier making that determination, and if you in the absence of that, or if a plan isn't in place, falling back on the Social Security Administration. Even before these rules were announced, it still could have been an administrative burden for you to be making that determination, and maybe it's only coming up a few times a year in your retirement plan. Do you want to have to go through all the hassle of doing that? And maybe you do, and you have good reasons for doing that. But if you are doing that, just realize that now you're going to have to make sure that you're fully compliant with these new rules. If it's someone else making that determination, and especially in the instance of an insurance company, it is still a good idea to double-check those vendor contracts for impartiality. While I think it would be rare to find something in one of those contracts that say, hey, the people making the decisions here, their bonuses are tied to the number of claim denials or raises or some sort of other financial incentives. It's still a good idea to kind of scan through to see if other things might catch your attention. And even if nothing doesn't, consider the next time you renew, asking the carrier to provide something specific in the contract that they'll be complying with these new rules, possibly adding an addendum to an existing contract. Again, just things to possibly think of now. If applicable, go through your plan's appeals procedures and make sure that the claimant has the right to review and respond. That was a bullet point mentioned on a previous slide. But as new information comes along and as new things develop, participants or claimants now have the ability to get more involved than they may possibly have had in the past. And then especially if you're putting out those denial notices, review those carefully. You need to make sure those are compliant. It might be a good idea, even if a third party is doing that, to scan some of those and to make sure that everybody is working through the rules as they should. Last two topics I'm going to cover here. The first one is on the new user fees for voluntary correction program filings, or VCP corrections. Again, I've got a hyperlink to a great newsletter up at the top here. But just jumping right in, you can see on this chart what the new fee structure is. It's now based on the assets of the plan, whereas previously it was based on the number of participants. And whether or not this is a good thing kind of depends on your particular situation. One thing that has caused a little bit of an uproar and is catching the attention of a few groups and some folks in Congress is that previously there was a reduced fee structure that was available for common mistakes. So for instance, if you had required minimum distribution errors, those types of failures, a lot of times those could be fixed for this reduced fee structure, and that could be like as low as $300. So a great thing. Those are no longer in place. Again, there's some rumblings out there, and there's a letter that we recently found from Congressman Neal from Massachusetts asking the IRS to, hey, maybe you want to reconsider the fact that this reduced fee structure was really great, and it really helped small businesses. So we're going to wait to see if this does anything. Don't know that it will. So for right now, at least for VCPs that are filed on or after January 2nd of this year, this is the new fee structure that's in place. And finally, last two slides here, last topic. As part of a recent Tax Reform Act, there were some new rules that were put out for retirement plan loans, but for very specific situations. So we're dealing with employees who have outstanding loans who then terminate their employment, or the plan terminates while the loan is outstanding, and then two, those folks roll over their accounts, including the loan, into another eligible retirement plan. And so the prior law said, hey, you participant, you've got 60 days to put all of your money into that new plan, including the full amount of the loan, basically repaying back the loan. Under the change, these folks will now generally have until October of the following year. So quite an extension of the time period for which to repay the loan. So what does this mean to you? And you may be saying, well, wait a minute, this seems like it's primarily a tax issue for the employee. And that is correct. And so you may not need to do much of anything. And in fact, no action may be required on your part, or no plan amendment may be needed, unless you have a plan that specifically addresses this issue, or maybe you have a loan policy that gets into these details and talks about the related timing. So again, it's a good idea maybe to read through your plan document, see what it says, if anything, about loan provisions. If you have a separate loan policy, giving that a scan. Of course, we're always happy to help with any of that here. If there are any employee communications that you prepare internally, maybe you give folks who leave and who have outstanding loans some sort of outgoing document to kind of help them know what they need to do. That would be the type of communication that you would want to review. You may want to reach out to your record keeper, see what they're doing. I suspect most of the larger record keepers, if not all of them, are on top of this, or at least thinking about it. But maybe have a little bit of a dialogue to see what's going on as far as what they are doing. And then finally, think about it from the perspective of now people will potentially have they do have a longer period of time to make the rollover contributions into the plan. So, maybe somebody joins your plan right away. They put in a significant amount of money. They may not be quite done yet because they have that additional time period to repay that loan. So from an internal procedure, consider, hey, is there anything we need to do on our end, any adjustments that we need to make for rollover contribution procedures? And with that, before I turn the time over to Chris, I believe Kayla has the CLE codes.
Yes, thank you, Isaac. At this time, I'll announce the code for those of you seeking CLE credit today. Please go ahead and just type it in the box you're seeing on your screen. The code is OMALH. I'll repeat that. It's OMALH. One more time. That's O as in octopus, M as in Mary, A as in apple, L as in llama, and H as in ham. We'll leave that open momentarily, and for those of you who are seeking credit in Kansas, New York, or New Jersey, please fill out the attorney affirmation form in addition to submitting the code, and email it to me, Kayla Hooven, at khuven@foley.com. And a reminder to all participants today, certificates of attendance will be distributed approximately 8 weeks to the eligible participants. And I'll leave this open briefly. All right, thanks. And now I'd like to turn the presentation over to Chris.
Thanks, Kayla. So joint employment is an amorphous topic, and it has been a very volatile topic. My intent today is to give some explanation more about what the landscape is with respect to joint employment right now, and understand that it is a rapidly evolving issue. So let me tell you where we've been. Historically, joint employment has been a doctrine where an entity would be deemed to be an employer of a contracted entity's worker. So, you hire a subcontractor to do a job, and if there's enough involvement or control from company A over contractor B, then company A might be deemed to be also the legal employer of company contractor B's employees. But you needed a pretty substantial level of control to make this legal finding, and for 30-something years or longer, this was relatively stable, where you didn't see a lot of change to the legal test. Joint employment really wasn't considered to be a risk area except for certain small businesses. You might hire an outsourcing company for certain work for a long-standing relationship. You hire a temp company or something like that to supply workers or something like that. That has always been the historical model for joint employment. But beginning, 3 or 4 years ago, all of a sudden there was this immediate and crazy focus on changing to a far more expensive joint employment standard, where the focus was no longer on the level of direct control, but merely the level of possible influence, even if not exercise. So you could have either indirect control or meaningful influence, but like I said, you didn't actually even have to exercise that influence according to this new standard that was being circulated by a couple of federal agencies. That was coming primarily out of the Department of Labor, obviously, as well as the National Labor Relations Board. And then with the change of administration last year, there was a fairly immediate response to concerns about joint employment, where the DOL immediately pulled back the Obama administration guidance trying to change some of these standards. And then the NLRB has now come out and purported to change the new joint employment standard back to the old joint employment standard. But even that is undergoing some rapid evolution this week even, which I'll touch on in just a second. What's the risk of joint employment before we kind of talk about what the political landscape is? Well, it becomes a concern because if you are deemed to be the joint employer of another company's workforce, it can raise some legal risks for you. It can increase what is considered to be your employee headcount. So if you were previously operating under some statutory thresholds for FMLA coverage, either overall or at certain locations, Affordable Care Act coverage, or anything other where you have to have a certain employee headcount to be covered, Warren Act, etc. Now, all of a sudden, if you're the joint employer of these other businesses' workers, they count towards your coverage obligations. Perhaps more concerning is the wage and hour implications of this sort of thing. If you're employing a contractor who is not on the up and up on their wage and hour compliance issues, or perhaps worse, is not aware of what the wage and hour requirements are that apply to them, in terms of minimum wage, overtime, things like that. Now suddenly you become potentially liable to satisfy those wage and hour violations, and that gives access to greater class action litigation, things of that. Since we're in the context of talking about benefits, there are benefits risks in terms of, are people supposed to be offered coverage under certain plans because they should be deemed to be eligible employees or eligible participants, and if you're not offering them coverage when you are supposed to, what kinds of risks are you opening there? And then you run into the labor relations aspect of this stuff, and this is really where the rubber started to meet the road with this, is that there are certain industries that have been historically immune to successful union organizing. And I'll give the example of fast food franchising. A lot of fast food operations are not managed and owned by the corporate franchisor. They're franchisee locations where they may only have a handful of employees. And it's just difficult to have any type of penetration as a labor environment into that. But if you are able to get the franchisor to be deemed the joint employer of all these various franchisee employees, now all of a sudden you have a materially large workforce that you can try and organize, and there's financial gain in doing so, whereas, the 10 to 12 employees at a franchise location may not necessarily make economic sense for a union. So all of this happened in response to what the Department of Labor determined back, I think, in about 2013 or 2014 to be the new, quote-unquote, fractured workplace, where the argument went anyway that increased use of subcontracting in industries was intentionally, farming out historically secure labor-friendly jobs, and now the unions were being frozen out. The employees were having less recourse for wage and hour violations, because if there were wage and hour violations going on at a small employer, the employer could effectively just Chapter 7 the business, protect themselves from the liability, and the franchisor has no risk in it because they're not an employee of this business. So the real reality of this is that there was a purported recognition by the previous administration that supposedly employers were using these tools to change their risk management scenario and eliminate some of these compliance risks as well as their potential penetration for union organizing by engaging in increased contractor relationships. And from a policy goal anyway, that was not something that the previous administration wanted to see happen. So that's where a lot of this came from. The real reality from my perspective, at least in speaking to employers, is that the landscape itself is what's really fractured. And this comes up in a number of ways, because so far I've really been talking about federal tests, right? But the test that the Department of Labor was using to give guidance on some of these wage and hour issues had some slight variations to the test that the National Labor Relations Board created to determine joint employment within the labor organizing sphere and whether businesses were covered by the National Labor Relations Act. You then port that level of complication out to the states, where now suddenly states have their own wage and hour protections. States have their own tax setups that they have to do, and employers are required to pay into things such as unemployment. In some states, there are paid leave contributions that are needing to be made, paid sick leave, issues like that. You have your workers' compensation standards. Employers are supposed to provide that. And if they're joint employers of all of these employees, they would have to meet these requirements, but the test isn't necessarily the same. For the Department of Industrial Relations in a state, they may be using a different test for workers' compensation purposes than an unemployment agency might be using to determine whether somebody owes unemployment contributions, and if so, what rate it is. So there's a nebulous web of requirements that would require navigation depending on how far you go down this joint employment rabbit hole that is, in fact, very fractured and difficult to comply with. This is really all political. I know we're talking about legal tests, but like I said, this became a response to the fact that we had a shrinking middle class, and other than in the healthcare arena for the most part, the participation and interest in unionization has been radically declining over the last several of decades. And there is one thing that unions can still do better than just about any other interest group in the country, and that's turn out a vote. And so despite the fact that unions have become less and less an economic reality and an economic factor for a lot of industries, they continue to have disproportionate political power and therefore disproportionately hold the ear of politicians and the bureaucrats they appoint. So this is really why I think starting in the Bush administration, for the most part, there was a heavy use of federal agencies to start affecting policy that couldn't necessarily go through Congress in the labor relations arena. And then the previous administration really took that to another level by aggressively using some executive orders and the federal agencies to start pushing labor policy that wouldn't happen through Congress. And joint employment was really a big one that the unions were pushing for because it gave them access to pressure mechanisms against companies and industries that they just historically have not been able to penetrate because of the nature of the industry and the nature of the relationships within it, and in particular franchise models. Okay. Where we are right now is that the NLRB still remains the epicenter of this joint employment political showdown, because even with a now Republican-appointed majority on the NLRB, it is still viewed as an overall labor-friendly agency. But that perception is quickly changing, because the current administration is appointing people and making it very clear that they are out to make business-friendly changes to these sorts of things. To the point where just this week, there's been a huge hubbub in the joint employment issue about the NLRB's attempts to throw out the old new standard and put back in place the new old standard, so to speak. And one of the individuals who voted on that case was an attorney at another firm who had previously advocated for the party involved on the joint employment issue. And the Inspector General, labor organizations and many Democratic senators and congresspeople were up in arms about the fact that the NLRB had taken this step involving somebody who had a clear conflict of interest and a clear bias with respect to it, to the point where the Inspector General came out late last week saying that this was improper, the NLRB hadn't followed its own recusal procedures, and so forth. And so on Monday, the NLRB vacated that decision, instituting or reinstituting, I should say, the old joint employment standard. So as of now, the Obama-era joint employment standard still purports to be the NLRB's current standard. But that's going to change again once the NLRB goes through its proper process and has the proper people on it. At least I expect that it will, because that's clearly an administration priority. But this little micro example gives just a little bit larger view into how political this has become and how non-legislative this has become, because the federal agencies are much more susceptible to this type of political machination. And as we get into a more and more partisan world, where there is less and less interest on compromising and more, we're in charge, so we're going to do it our way, to hell with what you say, thinking in Washington, I think we're going to see more and more of this. There is some effort in Congress, of course, now that we have a Republican-controlled Congress, to clean some of this joint employment issue up with respect both to the National Labor Relations Act and the Fair Labor Standards Act, which is the federal wage and hour statute, at least the primary federal wage and hour statute. The House recently passed in November what was dubbed the Save Local Business Act, and it's a very simple bill that simply defines what the joint employment rules are going to be for purposes of the National Labor Relations Act and the FLSA. That is now stuck in the Senate. There has been no action taken on it in the Senate since the House passed it. Presumably, if it gets voted on before the midterm elections, it would pass the Senate if they can get enough to get over a filibuster and signed by the White House. But it remains to be seen whether the Senate will take any action on that. What are the challenges for employers to have to deal with this shifting landscape of joint employment that's become so political? The challenges are multifaceted in my view, right? You're not only trying to figure out what is the applicable standard, today, and is it going to change depending on who's in charge and what the political wind, which way the political winds are blowing, but you also need to identify what is the legal issue that's happening here. Is it a labor relations question where I might have to deal with the NLRB standard on this, or is it a wage and hour question where I have to deal with a Department of Labor standard issue, or alternatively, is it a state wage and hour issue where now I have to look at state wage and hour laws, and you can imagine that states like, California are going to take a much more aggressive posture on this type of thing over a more conservative state. And from a policy perspective, seeing that things aren't going the way they want them to in Washington, they may be more aggressive about it in the state court system or the state legislator. So you have to figure out where the issue is surfacing and what is the risk spectrum. Am I talking about a benefits issue? And how big is it? Is it, 10 people? Is it 200 people that this potentially affects? Am I a joint employer only as to one contractor in one location? Or am I going to be deemed to be a joint employer, using basically the same contract in one state but not another, and how do I manage that? The other question is, are there even rules to apply? Right now a lot of the states have been relatively silent on this issue. So if you have a joint employment related legal risk come up in a state like, I don't know, I'm just going to randomly pick Minnesota, you have a good sense of where things are at the federal level in a moment in time, but you might not have any idea where things sit at the Minnesota level because there hasn't been any action on it. So you have to wonder about that and what the rules will be tomorrow. And then all of this has to be done within the context of maintaining your own brand integrity, service delivery platform, product quality control, et cetera, whatever your business is, because the surest and safest way to avoid any type of joint employment is if you need to hire a contractor to perform a job, relinquish as much control over how they perform the job as possible, but then you give up a lot of quality control in that, and that is a very concerning thing to give up if you're trying to avoid one legal risk only to take on another risk, which might be legal or it might be more business, and that your brand quality starts to suffer and you lose profitability and things like that. So this is not a simple issue, and it has a lot of different tentacles that touch on a lot of different things. I want to just add a quick comment on where I think the most at-risk sectors of the world are for this. Your very typical subcontracting relationships are generally going to be safe. If you're a manufacturing business and you have a long-term relationship with a cleaning company to come in and do something that is totally unrelated to your overall business model and is just an ancillary service that you need to do because you need to have, clean office space, that to me is not going to be a major concern area because, those really are two separate businesses. Where you are going to see the more common risks are where the contractor is performing some of the critical components of the overall business of the larger company. So, the franchise model is obviously a huge one, and that's been one that's been particularly under the microscope here. Construction is another one where you have a general contractor and you're hiring a bunch of subcontractors, but overall everybody is performing the same work, which is construction of a project, and the general is responsible for construction of that project. And then another one is basically where you're going to see the demographics of the employee workforce be susceptible to some kind of manipulation and labor organizing. And these are, I hate to call them this, but these are your sort of more fungible, low skill, low education jobs where there's not a lot of view of them as a career path per se. And typically, and this is obviously stereotyping, but we need to just be aware of the realities here. Typically, the individuals filling a lot of those jobs might not have the sophistication to understand the larger battle being played out here and are going to be susceptible to propaganda and rhetoric. So, not every industry is going to be at risk, but there are certainly a lot, particularly where within these industries there are long-term subcontracting relationships going on. So with that, I am going to I think we've got a couple of questions, but we don't want to keep them long here. I see I've got maybe 30 seconds, so I'm going to wrap it up. But just thank everybody for attending on behalf both of Isaac and Marian. Reminder that there is a short survey on this. If you have opportunity to fill it out, we would really appreciate it. And with that, Kayla, I'm going to turn it back to you to wrap up. Thank you.
Thanks so much, Chris, and thanks everyone for joining today.